In today's video, we're talking about pretrial motions, specifically what are pretrial motions as they relate to criminal cases in the state of Arizona. So when you're charged with a crime, it's important to understand that there are two really distinct phases. There are many more than this, but there are really two big ones that we're going to talk about for this video. One, you have a pretrial phase, and then you have a trial. So in the pretrial phase, we're talking about everything that's happening up leading to a trial. And oftentimes what we'll do as defense lawyers is we'll identify issues that require us to address them prior to going to trial. So we need to address them in the pre-trial phase. And these issues are very important, and we see these a lot. What we need to do is be very focused on what the issue is and then identify what type of motion we're going to be filing. So here on this whiteboard, we have just a couple that we want to go through with you today. The first one being a big one. It's a motion to suppress evidence. So let's say, for example, you're charged with a DUI. You go in front of a judge or your case is pending before the court. They will ask you, do you have any pre-trial issues? Are you going to be filing any pretrial motions? A motion to suppress in a DUI case is a pretty common one. What we're trying to do is actually suppress evidence that the government claims is evidence. We're saying this evidence is not reliable, it's not relevant, there's no reason for this evidence to come into court against you, against the defendant. And so we're trying to get certain things basically thrown out of court because they're not reliable. Things like blood results are predominantly the most common things that we're trying to suppress. There may be a problem in a chain of custody. There may be problems with how they tested the evidence. And so what we're trying to do is suppress that evidence. But the only way you can do that is to file this motion during a pretrial phase so that this issue is resolved before the case actually goes to trial. Sometimes these issues are not addressed up until the day before trial or the day of trial, but oftentimes they are. You can get them resolved in a pretrial process, and if you can address these issues early, you may not even have to go to a trial. The government's case becomes a whole lot weaker if they don't have any blood results that they can introduce. Another type of motion that's a pretrial motion is called a motion to compel. So this may be a situation where we want the government to produce something. They need to produce evidence that we think is in their possession, or we are asking them to give us or require one of their officers or a witness to give us a statement. We're saying we're asking the judge, we're asking the court to compel that witness or that police officer or that prosecutor's office to release evidence to us. We're asking them to compel them to release that evidence. Similar type of motion is a motion to preclude. So let's say, for example, that there's a person in court who is in the government's case to come in and testify. We're saying we don't want that to happen. We're saying this person's evidence is not reliable, it's not relevant, and it's not something that should be admitted into court. So we're asking that this specific testimony is precluded. It's not allowed to come into court. That's another type of pretrial motion. Also, there's what's called a motion in limine. What we're trying to do here is prevent certain types of conduct or certain types of testimony from being used in a trial. We see this a lot. A good example of this is in a DUI case where an officer will oftentimes want to, if they're testifying against the defendant in a DUI case, some officers do this, some don't, but they will want to actually stand up, go in front of the jury, and perform the field sobriety tests in front of them. So they're basically saying that they're explaining the field sobriety tests to the jury, and in doing so, they will actually walk a line or stand on one leg, or they'll show you how the pen test works. And when they perform these tests, they typically perform them very, very well because they're prepared. They practice these tests all the time. They're in ideal conditions. They're in a courtroom with plenty of lighting. There's no traffic whizzing by. They have the proper shoes on, things like that. So they'll go in front of a jury and they'll try to basically persuade the jury with their body language that this is how easy the test is. It's not a problem. Look how easy it is, and they'll show you and they'll go through everything and give you the same instructions that they claim that they gave to the defendant, when in reality all they're trying to do is kind of persuade the jury. So you can file a motion in limine to say the officer can sit at the witness stand and actually talk about those, but preclude that officer, prevent that officer from getting up and actually performing the test because it's really not relevant. It's doing more to kind of prejudice the jury rather than it is to explain the jury to the jury what the officer was trying to do. And of course, the big one that we always look for is a motion to dismiss. If there are issues that require the court to consider whether or not the violation of the law, whether the police misconduct, whether the missing evidence, whether any one of these things is granted, if evidence was suppressed, if evidence was precluded, what is the next likely outcome, or what is the next reasonable connection there? Many times it's to actually dismiss the case. We can say that there was a right to counsel violation that was so egregious that the case should be dismissed, or that the evidence was so improper, or the confession was taken in a gross violation of Miranda, and that the only proper remedy, the only conclusion that would result in justice would be to dismiss the case. So these are just kind of an overview of some of the motions that we file. There are many, many, many hundreds and variables and different permutations of issues that we address, but these are some of the things that we as lawyers are looking for. We're looking for issues, and then we're identifying what is the proper mechanism to address that issue, and then actually get the court to dismiss the case, or take the action that we're asking the court to do: suppress the evidence, preclude the testimony, or do something that we think is going to move the ball forward in your case. So if you or somebody that you know or love is facing a situation where they're facing criminal charges, where there's a question as to whether or not they may need to be filing pretrial motions, give our office a call. We offer free case evaluations. We'll look at your facts specifically as they relate to your case. We'll make a determination whether any of these motions apply to you and whether we can help you file them so that you can get a good outcome and a good result in your case. Free case evaluations, you have nothing to lose. Give us a call. We look forward to speaking with you soon. Thanks for watching.